Good morning, friends. Today, I will talk about two important provisions in the Constitution of India. That is Article 226 and Article 32 of the Constitution of India. We all know that in a democratic setup, judiciary plays a very important role. Why? Because it not only prevents the government authorities from using their power arbitrarily, but it also safeguards the rights of the citizens and even the very Constitution of India. Our Constitution of India has given us a strong, independent, and well organized judiciary. Article 32 and 226 empowers our Supreme Court of India and all the high courts to initiate an action against the government body in case of violation of rights, liberties of the citizen. Supreme Court and High Courts of India have under Article 32 and 226 very important powers, and they can use it at the appropriate time. Now, coming to Article 32, our most respected Dr. Bhimrao Ambedkar, while referring to the Article 32, said that it is heart and soul of the Constitution. No doubt, Article 32 is itself a fundamental right under Part 3 of the Constitution of India. It is also a right to constitutional remedies, which provides a right to protect our fundamental rights from violation. You can say that if any fundamental right is violated by the government, Article 32 comes into picture, and it empowers the person whose fundamental right has been violated to approach the Honorable Supreme Court of India for enforcement of fundamental rights. It has various parts. Under Part 1 of the Article 32, it confers the right to approach the Honorable Supreme Court for claiming or enforcing the fundamental rights provided under Part 3 of the Constitution of India. Under Part 2 of the Article 32, it empowers to the Supreme Court to issue directions, orders, writs such as habeas corpus, mandamus, sorceries, prohibition, and quo warranto for enforcing these fundamental rights. Coming to Part 3, Article 32, it empowers the Parliament to confer the power to issue orders, directions, and writs to any other court within the local jurisdiction of the India. So within limits of the India, it gives power to the Parliament to empower any court other than Supreme Court. So coming to Part 4 of the Article 32, it states that unless provided by the Constitution, the right to constitutional remedy confined by this article cannot be suspended. Is the Article 32 a basic structure of the Constitution? This was replied in the case of Fertilizer Corporation Kamgad Union versus Union of India. And in this case, it was held that the power conferred to the Supreme Court under Article 32 is an integral part of the Constitution and that belongs to the basic structure of the Constitution of India. Now, the area of Article 32 where it can be applied. In the case of Ramdas Athawala versus Union of India, it was held that Article 32 is applicable in cases where there is question of enforcement of fundamental rights. If the enforcement of fundamental right that does not arise, then this Article 32 has no application. And further, in the case of Nan Sukhdas versus State of UP, the scope of Article 32 was discussed and it was held to be quite narrow. Why? Because it can be enforced only in cases of violation of fundamental rights, which are under Part 3 of the Constitution. But even in another case of PUDR versus Union of India, it was held that Article 32 is enforceable against private individuals as well. So in this case, enforceability against private individual too was allowed. Coming to Article 226. This Article 226 gives power to the High Courts of the India to issue orders, directions, and writs in the nature of habeas corpus, mandamus, certiorari, prohibition, and quo warranto. As per Clause 1 of Article 226, every High Court within the territory of India has the power to issue orders, directions, and writs to any individual or authority, including the government, for the enforcement of fundamental rights as well as other legal rights under its own local jurisdiction. If we go by subclause 2 of Article 226, it gives power to the High Court to issue orders, directions, writs outside their own local jurisdiction in the cases where the cause of action lies wholly or in part within their local jurisdiction. Part 3 of the Article 226 talks about when an interim order has been passed under Article 226 by way of injunction or stay against the respondent, but without providing the copy of the petition and evidential document to the respondent and without giving an opportunity of being heard, then the respondent moves to the High Court to cancel the interim order and provide a copy of such petition to the petitioner. Then High Court shall decide the application within a period of 2 weeks of receiving such application or within the period of 2 weeks from the date on which other party received such application, whichever is later. So this is the condition when ex parte interim reliefs are given. Coming to Article 4 of Coming to Clause 4 of the Article 226, this power confers to the High Court under Article 226 is not in derogation to the powers conferred to the Supreme Court under Article 32, subclause 2. So, in case of Bandua Mukti Morcha versus Union of India, the scope of Article 22 was discussed. The scope of Article 226 is much wider than Article 32 of the Constitution of India, as Article 226 confers power to the High Courts to issue orders, directions, and writs not only for the enforcement of fundamental rights, but also for the enforcement of legal rights which are conferred to the disadvantages by the way of certain statutes and are an important as the fundamental rights. So there is a little bit more power under Article 226 than 32. As I have earlier told that these Article 32 and Article 226, there are 5 writs which can be issued under both these articles that are habeas corpus, mandamus, certiorari, prohibition, and quo warranto. So this is little bit short topic about these two important articles. I feel you might have enjoyed these articles. Thank you lot